Section 170 CrPC, cases to be sent to magistrate when evidence is sufficient. Subsection 1 says, if upon an investigation under this chapter, upon an investigation, this phrase must be remembered. Upon, this word signifies that when investigation is complete from the side of the investigating agency, when investigation is complete, it appears to the officer in charge of the police station that there is sufficient evidence. So it appears to the officers in charge that there is sufficient evidence or reasonable ground. Such officer shall forward the accused under custody to a magistrate. Forward the accused under custody. So this word under custody is something that we are going to explore today on the basis of a recent Supreme Court judgment. Just a few days ago, the judgment was given by the Supreme Court. So under custody. So what does this expression signify? Forward the accused under custody to a magistrate, empowered to take cognizance of the offense and to try the accused or commit him for trial. Or if the offense is bailable and the accused is able to give security, shall take security from him for his appearance before such magistrate on a day fixed and for his attendance from day to day before such magistrate until otherwise directed. So we will read only section 170 subsection 1 for the time being. We will explore other subsections later because the recent Supreme Court judgment has explored the concept of under custody. What does this signify? So a simplification is following now. So let's simplify the section. Upon investigation, number 2, appears to the officer in charge that there is sufficient evidence. If these two things have happened, means investigation is completed and the officer in charge feels that, or he is satisfied that there is sufficient evidence for establishing the guilt of the accused, and therefore the accused must be charge sheeted now. So this is the stage when the officer in charge has now decided to charge sheet the accused and let the trial go. So the two situations arise. If this is a non-bailable offense which the officer in charge is investigating, then the officer shall forward the accused to a magistrate who has power to take cognizance plus power to try or power to commit the case. Second situation, if the offense is bailable and the accused can afford to give security, then the officer shall take security from him for his appearance on the date fixed before the magistrate. So here, this is for bailable offense. For non-bailable offense, he must forward the accused to the magistrate under his custody. So what does the word custody signify here? That is what we are going to explore. The question that needs to be understood: is arrest necessary at the time of filing of the charge sheet? Means, does this expression under custody signify that the accused must be arrested by the officer in charge, must be arrested by the investigating officer and brought before the magistrate, because the section emphasizes under custody? So under custody is possible only when the accused is arrested. This means a plain reading of this section gives us the interpretation that the accused must be arrested. So even if the accused is already on bail or the accused has never been arrested so far, but he must be arrested for the purpose of charge sheet. Is this a correct statement? Can't the magistrate take cognizance of the charge sheet without production of the accused in custody of the officer in charge? Now, this question has arisen because in many cases, the sessions court have insisted that the accused must be arrested. And in many cases, the sessions court have issued non-bailable warrants. So the matter came up to the Supreme Court that whether these orders passed by the sessions court that the accused must be produced in custody, the accused must be arrested, and for that purpose, the non-bailable warrants were also issued. Is this necessary? So the Supreme Court has given us the answer. So I am reproducing whatever the Supreme Court has observed. First point, the word custody appearing in this section does not contemplate either police custody or judicial custody. So the Supreme Court says that here the word custody should not be taken in its ordinary sense. Ordinarily, we mean custody is either police custody or judicial custody. But such ordinary understanding of custody is not here. The Supreme Court says that it merely connotes the presentation of accused. So the word custody signifies the presentation of the accused by the investigating officer before the court at the time of filing of the charge sheet, whereafter the role of the court starts, means whereafter the trial will begin or whereafter the framing of charges will be done and then trial will begin, right, whatever. So the role of court starts after that, after the charge sheet has been filed. So the accused must be brought to the court. So either he comes voluntarily, he comes willingly, or he is brought by the investigating officer. But arrest is not necessary. Means he should not be in police custody for the purpose of coming to the magistrate. He should not be in judicial custody either, only for the purpose of coming to the magistrate on the eve of charge sheet. Second thing that the Supreme Court says, in case the police, that is investigating officer, thinks it unnecessary to present the accused in custody for the reason that accused would neither abscond nor would disobey the summons, as he has been cooperating in investigation, an investigation can be completed without arresting him, the IU is not obliged to produce such an accused in custody. So here, the Supreme Court has given us few situations. If it appears to the investigating officer that the accused will not abscond, will not disobey the summons of the court, will cooperate because he has already cooperated in the past, he has been cooperating in investigation. And if the investigating officer feels that he has all the evidences and does not require custodial interrogation, he does not require custody of the accused for the purpose of investigation because now it is complete, then why should he arrest? Should he arrest only because he has the power to arrest? If one has power, does that mean that it should be exercised even when it is not justified, even when it is not required, not necessary? So power should be utilized only when there is a necessity to exercise that power. The power should not be used only because it's there. So the Supreme Court further says, in normal and ordinary course, the police should always avoid arresting a person and sending him to jail if it is possible for the police to complete the investigation without his arrest. So the first thing that the investigating officer must see is that whether he really needs the accused person in his custody for the purpose of investigation. Does he need custodial interrogation? Does he need to discover something incriminating? And for that purpose, he needs the accused person in custody. Does he need to know about other accused persons, to know about other suspects, about which only the accused has knowledge? Does he need to trace money if it is a case related to some economic offense? If needed, then arrest. Otherwise, there is no need of arrest. And if the accused is cooperating, if the accused has joined the investigation, then what is the need of bringing that accused person before the magistrate in custody? Why is it necessary? So if it is possible for the police to complete the investigation without his arrest, and if every kind of cooperation is provided by the accused to the investigating officer in completing the investigation, it is only in cases of utmost necessity where the investigation cannot be completed without arresting the person. For example, a person may be required for recovery or for discovery of incriminating articles, weapons of offense, or if it is a murder case, then dead body. If it is a case of a robbery, then the wealth where it has been hidden, where it has been concealed, incriminating articles, for eliciting some information or clue as to his accomplices, means only the accused knows where the accomplices are, who are the accomplices, if there is a sense of conspiracy, if the investigating officer feels that there is some conspiracy, then who are the other persons involved in this conspiracy? Or if the investigating officer wants to know about other circumstantial evidences, then the arrest may be necessary, otherwise arrest is not necessary. Such an arrest may also be necessary if the concerned investigating officer or officer in charge of the police station thinks that the presence of accused will be difficult to procure because of grave and serious nature of crime, as the possibility of his absconding or disobeying the process or fleeing from justice cannot be ruled out. If this is the case, then he must be arrested if it appears to the investigating officer. And this should not be mere conjecture or mere surmise. It should not be just a guess. There should be some evidence to suggest that the accused has already made preparations for absconding, or the accused has made arrangements for disobeying the service of the summons. If there is something to indicate that, if there is something to show that, then arrest may be necessary, other arrest is not necessary. The refusal by criminal courts to accept the charge sheet without production of the accused persons is not justified by any provision of law. So this is the statement given by the Supreme Court, that if the sessions courts have made it a practice to insist that the accused must be brought in custody, then this is a wrong practice. This is not justified. No provision of law will justify the production of the accused under the police custody or judicial custody at the time of filing of the charge sheet. That's not necessary at all. Now the Supreme Court says, we are of the view that if the investigating officer does not believe that the accused will abscond or disobey summons, he or she is not required to be produced in custody. The word custody appearing in section 170 does not contemplate either police or judicial custody. It merely connotes or merely signifies the presentation of the accused by the investigating officer before the court while filing the charge sheet. So arrest is not necessary. We may note that personal liberty is an important aspect of our constitutional mandate. The occasion to arrest an accused during investigation arises when custodial investigation becomes necessary, or it is a heinous crime where there is incentive to abscond, where there is incentive to run away, or where there is possibility of influencing the witnesses, or the accused may abscond. Then he may be brought to the magistrate under custody. Otherwise, this word custody does not necessitate police custody or judicial custody. Merely because an arrest can be made, because it is lawful, because the police has the power to do so, does not mandate that the arrest must be made. So if the power is there, it must be exercised when it is justified. When it is not justified, it should not be exercised only for the sake of exercising the power because he has the power. A distinction must be made. This is an important statement, a very beautiful statement. A distinction must be made between the existence of power to arrest and justification for exercise of it. So there are two things. One, that the power is there, the power exists, and the other, whether the exercise of this power is justified or not. So here the investigating officer must see that it is justified or not justified. Justified, then exercise the power of arrest. Not justified, then don't. And for justification also, some evidences are required. Some conditions must be fulfilled, that there is fear of absconding, there is fear of influencing the witnesses, etc. That we have already read about. If arrest is made routine, it can cause incalculable harm to the reputation and self-esteem of a person. If the investigating officer has no reason to believe that the accused will abscond or disobey summons, and has in fact throughout cooperated with the investigation, we fail to appreciate why there should be a compulsion on the officer to arrest the accused. So this case was Siddharth versus the state of Uttar Pradesh. You can see the citation here. So this is all about section 170 CrPC, subsection 1. Right, here we are focusing on subsection 1 because this was the subject matter of consideration here in the Supreme Court judgment that I have just now indicated. In our next lecture, we will see what the Supreme Court has recently observed vis-a-vis section 391 CrPC.